Dear students, viewers, and the subscribers, welcome to the IAS Mentor. You are watching the Polity Prelims, you are watching the Prelims Preparation Mentorship Program 2026, and in that you are watching the day 3 Polity MCQs. The idea is that every day a target is given to the students, and as a part of the target to test the knowledge in those areas, 10 MCQs also solved. So the PDF file is already sent to the students, and for the explanation we are solving this here. All right, so come to the assertion come to the question number 1 which is basically an assertion and reason type of question. What is this question? Assertion is the fundamental rights are enforceable limitations on the power of the state to protect the individual liberties. This is definitely true. If you see, the very idea of fundamental rights in the constitution is that they wanted to limit the powers of the state, so they are very much enforceable. And that is the reason the fundamental rights are also considered to be the Magna Carta of Indian Constitution, which is trying to restrict the powers of the state. So assertion is definitely true. What about the reason? The Constitution allows the state to impose any restriction on the fundamental rights solely on administrative convenience. Now try to understand. Though the fundamental rights in the Indian Constitution are not absolute in character, restrictions can be imposed. But what are the areas on which the restrictions can be imposed? Is they are reasonable restrictions, and these reasonable restrictions are given in the Constitution itself. Therefore, it is not necessary as per the whims and fancies of the state and as per their administrative convenience they can impose a restriction. So this statement is definitely wrong. Therefore, what is the answer? A is true but R is false. That the assertion is true but the reason is false. So C is the right answer. Come to question number 2. Which of the following correctly matches the fundamental rights with their underlying themes? So this is again an important area. From the themes itself, UPSC asks questions. There are 6 themes of fundamental rights: right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights of minorities, right to constitutional remedies. So under these themes, you see different sets of rights are there. So right to equality, Article 14 to Article 18. Protection against discrimination and equal access to public employment. This is all there. 15, 16 and all those things. Right to freedom. Article 19. Protection against arbitrary detention. 20, 21. Freedom of movement. Again Article 19. So this is from Article 19 to Article 22. Right against exploitation. Prohibition of behavior. 23. Human trafficking. 23. Child labor. Article 24. Cultural and educational rights of minorities, Article 29 and Article 30. If you see that, protection against protection of interest of minorities and freedom of religion. Now the freedom of religion is not part of the cultural and educational rights. That is part of the right to freedom of religion. That is from Article 25 to Article 28. Therefore you can eliminate statement 4. Right to constitutional remedies, judicial enforcement of fundamental. This is true, where the writs can be issued. So there are only 5 statements. So Article 32 talks about the constitutional remedies or the writs. So which of the statements are correctly matched? So therefore our answers could be 1, 2, 3 and 5 only. 4 is not the right thing. So the answer is option A. A is the right answer. Alright. So with that we'll move to the question number 3. Just take care of the themes itself. Again I am repeating, from that there itself the question may come. With reference to the features of the fundamental rights in the Indian Constitution, consider the following statements. Again from the features, they may ask you the question. So from the features of the fundamental rights, statement 1, the fundamental rights are limitations upon the authority of the state but can be enforced against, but can also be enforced against a private individual. So try to understand that though the very objective of the fundamental rights is to ensure the limitation upon the powers of the state, it is not that the fundamental rights cannot be enforced against a private individual. So for example, untouchability against private individual, right against exploitation, 23, 24 against private individual. Even the Supreme Court has interpreted even Article 21 may be enforced against a private individual. So therefore, yes, this particular statement will be true. Some fundamental rights are available to both citizens and non-citizens. Yes. Some of the fundamental rights are available to both citizens as well as aliens. Say for example Article 14, say for example Article 21, say for example Article 25 to Article 28, right to freedom of religion. So these are all not reserved only to the citizens but may be available to the aliens as well. So this is also true. fundamental rights are absolute and cannot be restricted even on the grounds of public order or morality. The concept of fundamental right itself is qualified in nature. The fundamental rights are not absolute in nature. Also, if you know the answer for this particular statement too, you just put it in the comment box. Which are all the fundamental rights which are strictly restricted only to the citizens? While most of the rights are available to the aliens as well, some fundamental rights strictly only to the citizens. So, what is that fundamental right? The Constitution allows the Parliament to modify the application of fundamental rights to armed forces. This is definitely true and very much important for this year as well. So, the Parliament can restrict the fundamental rights under Article 33 of the Constitution when it comes to the armed forces. So, therefore, statement 1 is definitely true. Statement 2 is also true. Statement 3 is wrong. So, wherever 3 it is wrong. So, the right answer would be option A. A is the right answer. Please come to question number 4. What is the law within Article 13 of the Constitution? That is what is question number 4. With reference to Article 13 of the Constitution, which defines law for the purpose of fundamental rights, consider the following statements. The term law under Article 13 includes ordinances, orders, bylaws, rules, regulations, notifications, and customs having the force of law. This is all definitely true. The term law under Article 13 includes ordinary law, ordinances, bylaws, subordinate legislations, and even the customs which is having a force of law. But what is not law under Article 13 is a constitutional amendment. A constitutional amendment is not a law under Article 13, which has been clarified by the constitutional amendment, 24th Constitutional Amendment Act in 1974. The very purpose of Article 13 is to give primacy to the fundamental rights. That is, any law which is in violation of fundamental rights can be declared to be invalid. But however, what is not a law under Article 13? A constitutional amendment is not a law under Article 13. That means no constitutional amendment can be challenged in a court of law merely on the ground that it is violative of the fundamental rights. Any constitutional amendment can be challenged in a court of law on only one ground. On the grounds of what? If you know the answer, put it in the comment box. But anyways, I'll discuss all those things in the appropriate topics. Therefore, come here, constitutional amendments are included within the definition of law under Article 13. Definitely not here. The 24th Constitutional Amendment Act 1971 explicitly says this. Any law inconsistent with fundamental rights is void to the extent of inconsistency. What do you understand by this? Any law inconsistent with fundamental rights is void to the extent of inconsistency. That is also true. In fact, if it is a post-constitutional law, the doctrine of severability will apply in that particular case. Judicial decisions are expressly included within the definition of law under Article 13. The judicial decisions are not explicitly mentioned as law under Article 13. So, therefore, this particular statement will also be wrong. So, statement 2 is wrong and also statement 4 is wrong. So, therefore, we are left with only what is called as option A. That is 1 and 3 only is the answer. Come to question number 5. With reference to the philosophy underlying Article 21 of the Constitution, consider the following statements. We know that Article 21 provides for what is called as right to life and personal liberty. Article 21 protects the right to life and personal liberty not merely from arbitrary executive action but also from unfair, unreasonable and arbitrary laws. So, this is very, very important. After the Supreme Court said that no person shall be deprived of the right to life and liberty except in accordance with procedure established by law. This is what is there in the Constitution. But the Supreme Court said the expression procedure established by law will have the same meaning as that of due process of law, right? So, therefore, you will have to understand that after this expression due process of law, Article 21 provides protection not only against arbitrary executive action, but also against arbitrary legislative actions as well. The expression right to life under Article 21 includes the right to live with human dignity, and that goes along with it. The expression life under Article 21 includes not only the right to live with human dignity, but also that goes along with that means that anything that you take to ensure what is called as a dignified human life. This is the broadest interpretation that is given by the Supreme Court in the Maneka Gandhi case. Article 21 has been given an expansive interpretation by the Supreme Court through a series of judgments beginning the Maneka Gandhi case. This is a general statement, we know that. Only beginning the Maneka Gandhi case in 1978, the Supreme Court has said a lot of right to be implied under Article 21 of the Constitution, and interpretation has been given to Article 21. So, this is definitely true. So, which of the statements given above are correct? The correct answer is option D. All the statements are correct. D is the right answer. Please come to question number 6. Assertion and reason type. Right to freedom of religion is the theme for this particular question. Article 25 allows a state to regulate or restrict any economic, financial, political or secular activity associated with the religious practice. This is definitely true, because if you see the very constitution of India, the kind of secularism that we follow is a positive secularism, and the positive secularism allows for intervention, and not just in the religious matters but also the other matters associated with the religion, especially the secular activities surrounding the religion. The right to freedom of religion in India is subject to public order, morality, health and other provisions of the Part 3 of the Constitution. That means assertion is definitely true. What is the reason saying? The reason itself is saying that the Constitution does not give the religious right as an absolute right. It allows the state to intervene in the interest of public order, health, morality. So on these grounds, we may substantiate what is given in the assertion. All right. So therefore, this reason is explaining the assertion. And because the state has a right to intervene in all those things, so the state can appropriately make interventions with regard to what is given in the assertion. So what is the answer here? So both A and R are true, and R is the correct explanation of A. Come to question number 7. With reference to right to freedom under the Constitution of India, consider the following statements. Right to freedom means Article 19 to Article 22. The freedom guaranteed under Article 19 are available only to the citizens. Yes, Article 19 is only to the citizens. Already asked a question, what are the rights available only to the citizens? You can put it again in the comment box. But Article 19 is definitely only for the citizens. Protection against arbitrary arrest and detention is guaranteed under Article 21 alone. Whenever this extreme statement comes, alone, you should be very careful. In fact, Article 21 not only guarantees, but also Article 22. Article 22 provides protection against what is called as arbitrary detention. So, alone 21 is definitely providing, but 21 alone is the article providing, then it becomes wrong. A person arrested under the preventive detention laws must be informed of the grounds of arrest as soon as possible. In fact, a person detained in preventive detention should also be informed of the grounds of detention by the detaining authority, so that he can make a representation, although he does not have the right as that of what is called as a punitive detention, but he shall also be informed of the grounds of arrest. So that would enable him to make an appropriate representation to the detaining authority, but that may also be prevented in certain cases involving what is called as the public interest. So the detaining authority may not reveal, but mostly it has to be revealed. So therefore this particular statement is also true. The freedom to form association and unions can be restricted on the grounds of public order, morality only. It is not only on the grounds of public order and morality, but also on the grounds of the sovereignty and integrity of India. So only again an extreme statement. So therefore it becomes wrong. So statement 2 and statement 4 are wrong. So therefore you are left with option A, that is 1 and 3 only is the right answer. Please come to the next question. Again, assertion and reason. Article 29 protects the cultural rights of any section of citizens, whether they belong to a minority or a majority community. In fact, try to understand, Article 29 is not only for the minorities, the courts have already clarified it. Article 29 is for any section of citizens having a distinct language, script or culture within the territory of India. So it is not only to the minorities. So definitely assertion is right. What is the reason? The cultural and educational rights under Article 29 and Article 30 are available only to linguistic minorities. The cultural and educational rights under Article 29 and Article 30. In fact, the cultural and educational rights is available only under Article 30, not under Article 29. So it is available not only to the linguistic minorities, but also to the religious minorities. So therefore, anyways, this particular statement is completely wrong. So what would be the answer in this particular case? The cultural and educational rights under Article 29 and Article 30 are available only to the minorities. So therefore, the answer is A is true, but R is false. So the answer would be option C. C is the right answer. Please come to question number 9. With reference to the constitutional remedies under Article 32 of the writ jurisdiction of the Supreme Court, consider the following statements. We know that in Article 32, the Supreme Court can issue writs for the protection of fundamental rights. In fact, they can issue 5 types of writs. Writ of habeas corpus, writ of mandamus, writ of prohibition, certiorari and quo warranto. So what are these writs? Statement 1. The writ of certiorari can be issued both against judicial as well as quasi-judicial authority. Yes. The writ of certiorari is not only issued against quasi or judicial and quasi-judicial, but it can also be applied against the administrative authorities as well. Anyways, this particular statement is right. The writ of prohibition is used to prevent an inferior court or a tribunal from exceeding its jurisdiction. This is definitely true. That is why the writ of prohibition is what is called as preventive in nature. It prevents the lower court from exceeding its jurisdiction. Whereas the writ of certiorari is more of curative in nature. It is used to quash a wrong order that is already passed by a lower court. The writ of habeas corpus can be issued even in cases of lawful detention order passed by the competent court. No. A writ of habeas corpus is generally passed against what is called as an illegal detention, but it cannot be against a lawful detention which is based on a court order. So this is wrong. Article 32 is itself a fundamental right. Yes, it provides for constitutional remedies. It in itself is a fundamental right and cannot be suspended even during emergency. No. Under Article 358 of the Constitution, under Article 359 of the Constitution, they can be suspended. The only thing where their rights cannot be suspended under Article 359 is Article 20 and Article 21. So apart from that, the other rights can be suspended, including Article 32. So which of the statements given above are correct? So the right statement is, that is 1 and 2 only. Come to the next thing. Which of the following statements best reflects the philosophical foundation of the fundamental rights in the Indian Constitution? Fundamental rights grant absolute individual freedoms that cannot be restricted. So fundamental rights does not provide absolute freedom to anyone. So that is definitely wrong, because the fundamental rights are qualified in nature. Fundamental rights exist primarily to ensure social control by giving the state extensive powers over individual actions. Fundamental rights exist primarily to ensure social control by giving extensive state powers. See, the idea of fundamental rights is not to give extensive state powers. So rather its idea is to provide what? Its idea is to ensure basically the welfare of the protection of rights of the people. Fundamental rights operate mainly as a limitation on the state power to preserve liberty, dignity, equality of the individual. So this is definitely true. The fundamental rights are privileges granted to the citizen and may be withdrawn at the discretion of the executive. That is not possible. So anyways, the right answer is option C. So in this way, every day we will give a target to the students and we will also solve those questions, so that we help in making the students getting a better conceptual clarity. Now this is batch 1 of the Prelims Preparation Mentorship Program. If you want to join this program, you can reach out to us, or if you want to join the next batch is starting from 15th of December 2025, and the third batch is likely to start from 5th of January 2025. For more details, you can reach out to us in the mobile number that is given in the description below. Thank you very much and all the very best.